award is coming, but he's not here yet. First item on the agenda is public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
If you could let me know when I have 1 minute left, I would appreciate it. Members of the Commission, Ray Hartz, Director, San Francisco Open Government. This public comment is in reference to the Sunshine Ordinance Task Force Order of Determination number 10054, which was the basis of the Ethics Commission complaint number 06-110816. This order of determination was sent to this commission for enforcement and summarily dismissed by the staff without a hearing. Let me be perfectly clear. This is an issue of free speech. Not only is it free speech, but political free speech. Not only is it political free speech, but dissenting political free speech, which is protected by both the United States and California constitutions. The only reason for the position taken by the Library Commission in this case is to ensure that the dissenting political free speech and the political thought that speech represents does not make it into the official record of the Library Commission meetings. As opined by the Attorney General of California, quote, any attempt to restrict the content of such speech must be narrowly tailored to effectuate a compelling state interest. Now, you don't have to go too far to see an example of what it is when you addend something, how it affects it. Number one, it takes it out of context, which reduces the ability for anybody reading those minutes to understand it. And here is your own website, the meeting of January 10th, 2011. You'll see there in blue, it says, the second section, it says, Mr. Hartz also submitted a written statement which has been included at the end of these minutes.
Mr. Hartz, are you asking us to look at something right now?
Well,
if you're asking us to look at that screen.
You got a screen, son?
No.
Yeah. Okay. Well, I'll explain it then. If you page down to the bottom of the screen, it's not there. If you page to the bottom of the screen, my 150-word summary is not there. If you print out a copy from your website of the minutes, my 150-word summary does not appear. What you have to know is that little phrase up near the top that says a summary is included at the end of the minutes is a link. And if you click on the link, then the statement comes up. So basically what happens is, because the desire is to keep critical public comment out of minutes, the city attorney has taken the position that you can append it to the end of the minutes. Now if you read the Sunshine Ordinance, the clear wording of the law is, it be at the end of the minutes.
Thank you, Mr.
I asked to be told in 3 minutes, 2 minutes ago.
Good evening, Commissioners. My name is Patrick Menachog. I'm here on my own private time. I notice on the agenda for tonight's meeting and several of the previous meetings that my Sunshine complaint 013-014 have not been taken up by the body. It's been several months. When are you going to agendize it? I noticed on this agenda there's no mention of the Joel Gomez case. You referred to the mayor for enforcement. You need to agendize that and ask the mayor to show up during ethics question time. Get him to come down here and explain to you why that seminal case, the first case you'd heard referred from SOTF in a public meeting, and the first case that this body referred to the mayor for action, this led to no action. The mayor should be ashamed of himself that he didn't address this before the election. After all, who wants a mayor that's not going to obey ethics laws? So I would appreciate hearing when you're going to agendize my two cases for an open hearing. When you're going to agendize, following up with the mayor to find out what he did with your referral on this scope.
Good evening, Commissioners. My name is Dr. Derek Kerr. I came this evening to appeal to you to review a complaint that Dr. Maria Rivero and I submitted more than 2 years ago involving a potential conflict of interest between former Health Director Dr. Mitchell Katz and Health Management Associates. I just found out from Dr. Rivero that you will be discussing it in closed session tonight. So I wanted to thank you for taking this issue up. We've been waiting a long time, and we are both available if you need us to answer questions. We can appear in person or at any time at your convenience. Thank you.
Hi, Kimo Crossing speaking here. I wanted to say that I'm a little bit disappointed that the Ethics Commission is not being receptive to feedback they're receiving from the public and from city family in general. There's been a long clamor for televising of the Ethics Commission meetings, and yet only after the Board of Supervisors had their motion did you finally decide to do that. This argument, by the way, as Mr. St. Croix, that it costs money is ridiculous. I researched that issue with the SFGTV, and there are other departments that don't pay to have their meetings televised. In fact, the Board of Supervisors does not pay to have their meetings televised. It's a service offered to the city departments. Some do reimburse, but some don't. Of course, Prop F failed miserably, which was but the idea that the ethics could rewrite the law after the public had adopted certain provisions was disappointing that was even proposed. I want to say that I'm sorry that Ethics Commission has been reluctant, has refused to respond to the Sunshine Task Force's request for a joint meeting. About 2 years ago, I attended a joint meeting with SOTF and Ethics, and it was, I thought it was very effective. I think both the current commissioners and the Sunshine Task Force learned a lot about each other and their processes. And now I understand that the Supervisor Campos is basically forcing Ethics to have a joint meeting. Well, I mean, come on. I mean, how many times are you going to be forced to do things? This is really getting out of control. And the last thing I want to say is that I'm disappointed that this response to SOTF's feedback on the ethics sunshine regulations is essentially almost no notice provided at all. It was made available Thursday, 123-page document, and I would strongly encourage that that discussion item be postponed to allow the Sunshine Task Force to respond as a body to that very lengthy document. Thank you.
The next item on the agenda is consideration of draft regulations regarding the Commission's enforcement of the Sunshine Ordinance. St. Croix, would you please this matter?
In 2010, we brought some changes to the regulations of how ethics handles sunshine referrals to the Commission. A few of the proposals were adopted, and we sent them over to the Sunshine Ordinance Task Force for comment. They did a pretty exhaustive amount of work and sent back recommendations to us, which we in turn reviewed. The staff did a very thorough rereading of the ordinance itself and synthesized what you have before you as a result of reviewing the Sunshine Ordinance Task Force wished, and a very clear, sober reading of what is actually in the ordinance itself.
So there are a number of decision points in the staff's memo. My plan is to take them one at a time, although to take decision point 1 first, then 2A and 2B, followed by all those under decision point 3, followed by those under 4, and throughout, such that we would have public comment on each number decision point, but not on each subsection. Mr. St. Clair, would you like to summarize the changes in the preamble?
Essentially, the staff is saying that the commission only handles allegations of willful violations by elected officials, department heads, and managerial city employees who have the decision-making authority over the sunshine requests. There seems to be an intent in the ordinance that people ultimately responsible for these decisions are subject to the requirements of the ordinance, but the way it's worded, this section only refers to elected officials and department heads. So what we're trying to capture is also those personnel that either are designated by department heads as ultimately responsible for document requests, or otherwise defined in charge of those decisions.
If the other commissioners agree, I would like to take public comment first before we do our discussion. Decision point 1.
I'm Alan Grossman, and I'm truly appalled by your decision to proceed on what has taken your group and the Sunshine Ordinance Task Force the better part of 2 years to put together in the face of the following. Your staff ignored the task force request to see the report proposal in advance, provide comment on it officially. They got it on Thursday. Actually, they didn't get it, their administrator got it. Today is Monday. Secondly, the request to have a joint meeting to discuss their comments was also ignored. Third, this package is 123 pages. You couldn't have gotten it before we did. And yet you're going to move on it in 2 days. Fourth, Supervisor Campos has plans to schedule a government audit and oversight committee review and possible legislative solutions to any areas of open access government enforcement that need to be addressed. And finally, and to me, most disturbing, is the staff says that the Commission has officially retracted its decision to hear Sunshine Ordinance Task Force enforcements of its orders on simple violations. We don't know when that was done, whether it was done at a scheduled hearing. Nobody knows, because that was never officially made a part of any agenda of yours. I have before me a memo that lists 4 important legal principles that are not even mentioned in the report. Section 15.102 of the Charter. The first sentence of Section 3B2 of Article 1 of the California Constitution. The second sentence of Section 3B2 of Article 1 of the Constitution. And finally, 6735B of the Sunshine Ordinance, all of which are very relevant to these proposed regulations. They're not even mentioned. 6535B is actually quoted in full, but it's never referred to in the discussion of simple enforcement cases. So I'm willing to spend the time and read this to you, but I think at this point, to take up these decisions in the face of all of the time and effort that's been put in on the part of the task force members and of those of us who worked with them, and I've spent actually hours with Susan Harriman before she left the commission.
Thank you, Mr. Grissman.
Thank you. I'd like to leave copies of this. That should be.
Patrick Manette again. The Ethics Commission is again displaying mind-boggling hubris, proposing regulations stipulating how it will or not handle sunshine complaints referred for enforcement. Decision point 1 asserts ethics will, quote, enforce or review only allegations of willful sunshine violations by elected officials, department heads, managerial employees, wrongly exempting other city employees who may violate the sunshine ordinance. Ethics wrongly believes it isn't tasked anywhere in the ordinance with enforcing orders of determination from the task force. Instead, you appear to believe that only the district attorney or the attorney general are tasked with enforcement. None of the proposed decision points in these proposed regs were approved by the voters. Ethics may not adopt mere regulations that overturn sunshine open government laws voters have passed at the state level and or the local level. The proposed regulations are a bold attempt to repeal significant sections of the Sunshine Ordinance. Voters passed Prop G in 1999, creating the Sunshine Ordinance. Your job is to ratify the voters' will, not to overturn it, as Prop E and Prop F would have both allowed last week on November 8th. We, the public, do not trust this Ethics Commission to suddenly become an effective watchdog of the public interest with these proposed regulations. Following defeat of Prop E and Prop F last week, it's shocking that you didn't learn your lesson. You can't overturn the will of the voters by a mere regulation. Hubris. Too much hubris on that side of the table.
Hi, Kim Crossman here. I want to elaborate on some of the analysis that Mr. Grossman mentioned. I think one of the most notable points here is this section in the California Constitution. This was Prop 59. This was a provision adopted by signature to put it on the ballot, and then was adopted at 83% of the voters of California changed the Constitution. It was the Open Government Prop 59 provision, and what it says is a statute, court rule, or other authority, including those in effect on the effective date of the subdivision, shall be broadly construed if it furthers the people's right of access, and narrowly construed if it limits the right of access. Yet, what ethics staff is doing is just the opposite. They are pointing out every ambiguity and then going to the most narrow reading of the provisions possible. That's directly against the requirement in the California Constitution. So right there, that's anything you do, as Mr. Manisha said, a regulation can overrule a law, state law for sure. Secondly, if you're going to make a new ruling, you also have to look at this Prop 59 provision. It says, a statute, court rule, or authority adopted after the effective date of this division that limits the right of access shall be adopted with findings demonstrating that the interest protected by the limitation and the need for protecting that interest what findings have been adopted by the Ethics Commission to validate and prove that these regulations meet that test? Again, the test is that findings should be demonstrating the interest protected by the limitation and the need for protecting that interest. You haven't done that. You can't make any adoption of any rules until you make those findings. That's a violation of the California Constitution. I think I'll leave my points there.
Commissioners, Ray Hartz, Director, San Francisco Open Government. These comments reference decision point 1. If the Ethics Commission decides to adopt this staff recommendation as is, common sense says it will result in any person making a public records request directing that request specifically to, quote, elected officials, department heads, and managerial city employees, unquote. If they do not, they will be in the position of working their way through a bureaucratic thicket until they reach, quote, elected officials, department heads, and managerial employees, unquote. Or worse yet, have to appeal to the supervisor of records, read city attorney, whose office has repeatedly proven to be hostile to records requests, representing everything in terms to which attorney-client privilege applies. In the alternative, failing to do so would place the requester dissatisfied with the response in the position of appealing the matter to the Sunshine Ordinance Task Force without the possibility of any enforcement from the Ethics Commission. I ran into the same situation with the Library Commission. I put it to the Library Commission. They were found in violation by a unanimous vote. It was referred to you and it was dismissed because the person was not a managerial employee, etc. So I have filed another complaint against Luis Herrera, who is the city librarian, is of course a managerial employee, etc. And therefore it will be one way of eliminating that excuse for not hearing the complaint. And bottom line is, any person who understands this law at all will stop requesting anything from anybody below those three positions: an elected official, a department head, or a managerial city employee. I know I'm directing all of my public information requests to the department head. They keep sending me back, saying, you have to do this to the custodian of records. And I go, no, the custodian of records is not a supervisory employee. So if she does not imply or replies improperly, I have no avenue, because the only thing I can get is a determination for the task force with no possible chance of an enforcement from this body. So basically this is, if you put it in this way, it is going to simply put people in a position where every single request in a department will go to the department head, and every single request will go to some supervisor or managerial employee. Now, bottom line is they will still be responsible for doing it. They may delegate it to anyone, but as I learned in the Navy, delegation is not abdication. Just because I give it to an employee who is not a managerial employee doesn't mean I still don't maintain responsibility for that person doing their job and replying appropriately to that records request.
Good evening, Commissioners. My name is Hope Johnson. I'm the chair of the Sunshine Ordinance Task Force. I will try to address them point by point. I have a couple of comments, and I hope that I capture the point that you're on, but if I don't, I apologize. Let me start by saying I really encourage you to have a joint meeting with the task force, because we have a lot of experience hearing these cases, and that makes a huge difference. In fact, you guys have only heard one, and your staff had to change its policy directives because you realized they didn't fit with what a hearing is really all about. And we have a lot of people on the task force that have heard lots of these, and they can at least guide you so that you wouldn't be changing them as you have the hearings going along. So I just think that demonstrates why we want to have a joint meeting. Even if we don't necessarily agree, we have a lot of experience to pass on. And then to address the willful violation, on page 5 of the memo that your staff had online under section 3, complaints alleging willful violations, and the 1, 2, 3 third paragraph, it says that the commission doesn't have jurisdiction to handle the complaint, and yet in Appendix C of the city charter, throughout Appendix C, it makes references that your duties with respect to the charter and city ordinance can include opinions, oral advice to managerial employees that are required to say that they have training under the Sunshine Ordinance. So the fact saying that you don't have jurisdiction is not consistent with the charter under Appendix C. And also, Ethics Commission staff has been dismissing referrals from the Sunshine Ordinance Task Force. And if you don't have jurisdiction, then you certainly don't have a basis to dismiss task force findings. And, I think that the dismissal wording is probably misleading to the public. And then on page 10 of the memo, under the number 2, the task force proposed to define willfully. In that second paragraph, in the last sentence, it says, in the context of the Sunshine Ordinance, a willful violation would occur if a respondent purposefully withheld public documents or violated public meeting requirements knowing that the Sunshine Ordinance required otherwise. That word knowing is a suspicious loophole to me, because Section 6733 of the Sunshine Ordinance requires that city department heads, managerial employees, and others are required to submit to the Ethics Commission a signed affidavit that they have Sunshine Ordinance training. So they have a requirement to know. And when you put that word knowing in there, it means you're going to determine something that they're already in the law required to know. So that's just an example. Thank you.
Ms. Johnson, I actually have a question for you.
Yeah.
So looking at 67.35, does the task force believe that, my understanding reading the letter from the task force was that the task force does not think that the Ethics Commission should be the place where non-willful violations should be instituted. Is that?
Say that again?
That non-willful violations of the Sunshine Ordinance should not be brought in the first instance to the Ethics Commission. Do I correctly understand?
Well, the Sunshine Ordinance allows people to bring willful violations directly to the Ethics Commission or to the Sunshine Ordinance Task Force should they choose to.
Right.
We hear whatever complaints come to us, sometimes they're willful. But when we refer something to you, that's where the two, our opinion with the staff differs.
Okay, so you agree that non-willful violations of the Sunshine Ordinance should not be brought in the first instance?
No,
to the Ethics Commission.
Yeah, in the first instance, and that if we refer it to you, it's not necessarily an investigation. That's something that I have another point about in your memo, but it might not fall under willful violations, so I'm going to wait until you get to that particular point, but just, if that answers your question.
Thank you, Ms. Johnson. It does, and I also appreciate your personal invitation to the task force.
Thank you.
Commissioners' comments on decision point 1. This was it was a lengthy analysis that was provided by the staff. I think a good one. There was a lot of material, and I certainly devoted a lot of time to looking at it, and I'm sure my fellow commissioners did as well. I do, however, want to explore with the commissioners whether it would be prudent to talk about each decision point, but perhaps reserve motions on them either until the end or if we decide that perhaps further meeting with the task force or other public participation might benefit us in coming to this, in resolving these issues. Commissioner Stedman?
I think that would be very helpful for a couple of reasons. One is a number of these are interlocking. They questions related to, as the Chair just said, some of the issues flow through other decision points, and while we've tried to make it discrete, I'm not sure that any one of them stands by itself completely until I've heard the discussion. This ordinance has serious ambiguities and gaps. One of the problems is that we are struggling with a complicated document and two different sets of expertise in history. And I think we have made some progress in the back and forth to understand the issues better and to work our way toward manageable solutions. And as Ms. Johnson said, even if we don't agree on the particular solutions, I think there could be some value in both going through it at a reasonable pace so people don't feel that we have to do it this minute, and also just seeing at the end whether it would be helpful to have a joint meeting. I think that that and the time for reflection, I think one is well taken. This is complicated stuff to reflect on in just a few days. So I appreciate your suggestion that we walk through all of it, where we see clarity and where we might to pursue.
Okay, and I would like to add also that I think in many respects, now having the staff's memo, which again I think is a very thorough job, and I think the proposal also is quite thorough. Now having that, I also actually think now having some sort of meeting with the task force would be particularly productive, or at least have the opportunity. With respect to the specifics of decision point 1, any comments from the commissioners?
Sure. I'll ask one that was hard for me as I was reading through this again. It seems that there are two issues here in terms of scope that is related to our jurisdiction over willful or all violations, and over the actors who might have, against whom complaints might be lodged. That it appears that, I wonder whether in one case we aren't sticking with the actual, trying to do this without too many negatives in the document that already talks about willful and non-willful, so I'm trying not to get tangled. It appears that in one respect, related to the code authority, we are sticking closely to the literal words about willful violations. In the other, where the only people referred to are elected officials and department heads, we are considering adding managerial city employees. And I would just be interested in how we square that with the interpretive provisions. Is that in one case saying that's what it says we have and therefore that's what we have, and in another case we're expanding it, and if not, to just articulate some help in articulating the distinction. And I think the constitutional principles that we refer to may be part of the reasoning.
So I mean I share a similar concern, and I think one way to perhaps address it is for the second sentence of 67.34 to not. I don't think we should be trying to add managerial city employees into that sentence. I think that we can define, perhaps we can define department head or department heads broadly enough to encompass those to whom the department has delegated the authority to respond to these complaints. That's something that perhaps we should look into, but something I think worth considering, because I am concerned that we aren't adhering to the plain language of the ordinance if we try to add managerial city employee into that sentence. same time, I think if we're going to be consistent with the task force's recommendation that we do not, in the first instance, hear non-willful violations, to me the only way to reconcile that position with the ordinance is for us to not handle non-willful violations at all. Because there's 67.35 does not appear to provide any basis, unless our jurisdiction is limited to willful violations, for us not to take non-willful violations as well. So to me, reconciling that those two sections requires, one, limiting our jurisdiction to willful violations, and two, defining department heads in a way that encompasses perhaps not just the department heads, but those who have the authority to act on behalf of the department.
If I could just add one point. I find it frustrating, that's what I meant about the ambiguities in this, that in the case that one of the speakers referred to, that if we don't have jurisdiction over the people who are really supposed to provide the information to the public, then we can see that the information was not provided, but if the actor doesn't fit within our jurisdiction, we're stuck and there's nothing we can do, and that is frustrating and limiting. On the other hand, I can picture somebody who is not defined in the ordinance saying to us, where did you get the authority to define me, to penalize me because you don't have jurisdiction over me. And that's what I mean by the gaps in what might be the hope behind the ordinance, but not embodied in the words that we have to work with. And that is a source of frustration for people who are looking to us to be able to do something that we may not legally have the tools to do. So our solution may be outside, the solution to some of these could be outside or back and forth between us if we actually say there are revisions that need to be made. And when we put it here or there, you can't have the actors who might have failed to carry out a responsibility that the public wants to see effected, to have no tool to handle a failing that the law wants us to get at, but we can't reach the players who may be the ones who had the responsibility for carrying out. I like your notion of if we can build on the department head's responsibility as opposed to drawing in a new set of people, but actually saying the department head in some way through the person to whom if that solves it, I'd appreciate that way of being able to judge.
Commissioner Hand?
Well, and I guess my question is, can we not add language that simply says willful violations by elected officials and department heads and employees that are under their department or where that report to them? Is that not narrow enough, or is it too broad? I mean, essentially, if you're a department head or a manager or an elected official, I mean, you are ultimately responsible for whatever goes on in your department or your area of jurisdiction. So that if I'm the head of a department, I assume that anything that goes wrong within that department ultimately comes to my desk. So why cannot that philosophy be applied? Some simple language that then allows us to take the department head to task, even if in fact the violator is some clerk somewhere that willfully denied some aspect of the Sunshine Ordinance.
I'm happy to let the interesting query of the city attorney address this if I can't. But I think the issue is the ordinance itself provides for us to handle complaints against department heads and elected officials, and so we're trying to stay within the bounds of the ordinance, but provide enough clarity such that we can effectively implement it. So that's why the idea of defining department heads to include their specific delegates who have final authority over the issue might sort of balance those concerns.
I agree with that. Sounds like there are two different kinds of discussions, two different ideas that are floating here. One, Commissioner Hand, you're suggesting that all violations of the Sunshine Ordinance should be, the department head could be penalized for any violation of the ordinance. And Commissioner Hearn, I think Commissioner Studley are saying ultimately the commission should be able to penalize specific individuals, not just the department head, who have final authority over sunshine, sunshine responses. So I think the question that the commission is grappling with is, who exactly can you impose penalties against? And I agree that the reading of the ordinance that a willful violation by anyone in the department is a willful violation by the department head. It's probably a stretch factually.
But when we introduce a new class of employee into this,
No.
sure.
Managerial already.
I'm not talking to you. And when public comment is available, then you can speak. Okay? So we introduce a new class of employee that's subject to this. But don't we also introduce a new defense? If a managerial employee is saying that I'm not releasing the documents because I'm being told by my department head not to, is that a defense from a willful violation?
Or a shift
So
to
if
the department head.
if it's an elected official who's responsible or a department head, there's no such defense. Well, in the case of department heads, they're appointed by the mayor. But
I mean, in that instance, I would think that the person bringing the complaint could name the department head as the respondent. If they're being told that I'm not providing this to you because the department head has told me that I cannot fulfill the request.
well, they might call the complainant or they might not. But they might present as a defense in a hearing that it was because I was directed by my department head not to release it. Is it a defense?
So would that go, then that would go to the question of willfulness?
Yes.
Have they proved a willful violation? Being told to carry out orders, directives to somebody else. Then maybe in that instance, I mean, then Ms. Givner, would we be able to find a willful violation against the department head, even if they were not specifically named, if that was sort of the defense that came up?
It's all in how you write the regs. I think that sounds, what you're describing sounds like a willful violation by the department head, and you just want to write the regs in a way that captures that possibility.
So on that point, actually, Mr. Givner, can you talk a little about what the commission's authority is for drafting these implementing regulations, and are there any parameters? I mean, obviously, we have to make sure that regulations reflect the intent of the ordinance. And is that the only parameter, or is there anything more specific than that?
Yeah, that's the primary parameter. You know, unfortunately, there's not much in the legislative history of this ordinance that goes to exactly how the ordinance was intended to be enforced at this level by the Ethics Commission. So you're really looking at the words of the ordinance, putting these two provisions or three provisions together, and as Commissioner Studley said, there's several reasonable ways, I think, to read these provisions.
What about the Constitution?
And so it's a matter of coming up with what is the most reasonable interpretation in light of the overarching intent of the ordinance, which was to ensure public access to
Mr. Givner, reference was made to some of the constitutional provisions in this area. Could you speak a little to how we might turn to them, or is that something we should?
I can speak off the top of my head on that. Say, you know, right now, taking what Mr. Crossman and others said about the constitutional provisions, say as I mentioned, the ultimate goal of these regulations will be to effectuate the purposes of the ordinance by coming up with an enforcement mechanism that's true to the letter of the ordinance. And I think those goals, the goals of the ordinance, are consistent with the goals of the constitutional provisions that were meant. If you'd like more specific discussion of the facts of the constitutional provisions, I'd have to do it.
Okay, maybe we may want to see how the chair decides to proceed.
Okay, so my recommendation is that we move to the next decision point without a vote. I think we've expressed our views on Section 1, and personally I am in favor of the staff's view, except for redefining department head rather than inserting managerial city employee. But in my view, given the complexity of the issue, it may be worth deferring voting on this. I would be happy to hear from Mr. St. Croix and the other commissioners.
Are you planning to go to then look at this on just a discussion as well?
That was my thought.
Given, I was just wondering if given your estimate of how long the other items would take, might you want to set an amount of time in which you could all of them to some degree?
Well, I think the staff did a lot of work on this. I think, and like I said, I think they did a good job on it, and I think it would be helpful for us to have as clear a sense of what we think the issues are and know them well, so that if and when we address this with the task force, we'll feel like we're very well prepared to do so. But St. Croix, was there anything else you wanted to? Timing-wise, the issue, not the timing of the meeting today, which I'm sensitive to, but with respect to getting these finalized, I mean, we received from the task force their response in August. You guys, the staff has now prepared this memo. We're discussing it today. I assume, and perhaps Ms. Johnson can speak to this, that the process that we've described right now is, although it would take more time to get regulations in place, you feel it could benefit the regulations we ultimately adopt. Is that a fair characterization?
Yeah, there's a couple things I'm surprised you didn't tell them, that there are really specific exemptions. The discussion we were just having, there are really specific exemptions under the California Public Records Act, and that California law trumps all of our laws. And saying that your boss told you not to do it or didn't do it, that's not one of them. And so some of the things that you think are gaps, they are covered under the California Public Records Act. Some of them are gaps, and they do need to be revised, and we did work on that. But some of the, in state law, documents are all public, and it's the city's burden to show an exemption to keep them from being disclosed. So it's a little bit different from the legal world, where it's the opposite, where the plaintiff has to come in and say, you should disclose these, and that's all under the California Public Records Act, which isn't in here. So that's some of the things that will come up when you hold these hearings, if you do, which is why I think that some of the experience on our task force, including DCA Threet, who helps us, advises us on the task force, he could also have some assistance in this too, because he's been there and has those things come up. We also hear of jurisdiction under the California and the Brown Act. So some exemptions the Ethics Commission couldn't, you could put them in your regulations, but they would be in violation of the state law.
My question, and I appreciate that clarification, but my question is, one of the reasons we're here and trying to do this so quickly is because we are sensitive to wanting to have regulations that we think are going to be effective and make sense and do the best we can to interpret this ordinance. And having a process where we now will delay implementing these regulations in order to hopefully improve our response is going to lead to these regulations not being adopted tonight, and is going to result in them taking probably a few more months. But if you think that's a good idea, to me that would be helpful.
I do think it's a good idea on the condition that we might have some kind of interaction with you beyond just going through Mr. St. Croix with the actual commissioners, so they can understand some of the things that actually come up in hearings, because I think that that it will help you understand where we're coming from. This idea that sometimes the California Public Records Act, so if you had a meeting with us pushing it forward a few months, it would definitely be beneficial. Even if you don't, I still think that it would be beneficial, and Supervisor Campos may call us in front of the Government Audits and Oversight Committee in that time.
Decision point 2. St. Croix, would you like to use those that I'm hearing?
So it covers the issue of handling non-lawful complaints, the timing of scheduling of hearings, making it clear that hearings on these sunshine issues will be public.
Public comment on decision point 2.
Good evening again, Commissioners. Decision point 2 says the Commission does not have jurisdiction to handle non-local complaints. Commissioner Ward's response to me during the previous decision point, some of the questions by Commissioner Smutley proved that the Commission doesn't know what you're doing, which is exactly why you should table this for another meeting. You are not, Commissioner Ward, introducing a new class of people to 67.34. 6734 currently reads elected officials, department heads, and managerial employees. It's there. You're not introducing anything new. To the extent some of the commissioners may not understand that, you need to go back and read the sunshine ordinance before you pass any kind of regulations that will alter the sunshine ordinance. As I said earlier, this body is not allowed to overturn the will of the voters. The voters very clearly passed Section 6734 that includes managerial employees. You are not introducing anything new. You may not take it out without going back to the voters and asking them for permission to take it out. To that extent, you can move this along quickly tonight, and instead of going through 9 or 12 decision points, one of you could introduce a motion to table this discussion until after you rightfully meet with your peers on the Sunshine Task Force and the Supervisor Campus. And if there is any ambiguity in points in the Sunshine Ordinance, you might avail yourself of requesting Assemblyman Tom Amiano to come and help clear up some of the intent of the original ordinance and the amendments that were passed by the board. Not as if Sacramento is on another planet. You can get him over here to find out what some of the intent of the original language was.
I recognize that you have a need to get these regulations adopted, but I think the cost to the community would be unimaginable to somebody who spent years looking at the problems associated with enforcement of the task force orders. And I'm as close to that probably as anybody here, having actually had to sue the commission to get information on why these cases were dismissed. And that pattern has continued. But I think the basic issue is you better decide what your role is going to be. You're either going to be the instrumentality that I think everybody in this community believes is the one who enforce the Sunshine Ordinance. The district attorney has declined to do it. The attorney general has declined to do it. And you are the only other body that has that capability. And under the charter, you have the obligation, once you adopt these rules, to affect the purposes of the ordinance. And the people, when they adopted it in 1999, they were really serious that this was an important factor. So by parsing around as managerial employees included, ooh, this one or that one, you're missing the boat totally. The real question is, are you going to take your responsibility and enforce the orders of the task force? Because that's the place where everybody goes to get relief, and that's the place where they're going to get it as far as the task force can do it. And then when it shows up before ethics, if you insist and say that we don't handle enforcement, we only handle willful violations, then you've just eliminated 95% of the individual requester's ability to get public records or to be properly heard at a public meeting. And I say this with all due respect. I'm a lawyer. I practiced over 60 years. I just came back from my 60th law school reunion. And I can tell you, I know more about these issues than your staff. The two lawyers who wrote this report, their combined experience is what, 12 years, 9 years? I've lived with this for years, and I'm associating that fact, the fact of my experience and knowledge, with the responsibility that you have to write this and
Thank you, Mr.
adopt
Grossman.
regulations.
And while I appreciate your experience, and I think you have added to this process in the past, and I'm sure you will again in the future, I do not appreciate any attempt to denigrate the fine work of the staff.
Sorry, I'm hearing it. I missed your last time.
I said I don't appreciate suggesting that just because the staff has less experience than you means that they can't do a good job on these regulations.
Well, it wasn't meant disrespectfully, I assure you. It only means that in certain professions, experience really matters.
And he said,
Thank you.
Thank you.
Hi, Kim O'Crossman. You know, there was a discussion about experience, and I think I'm going to continue on with that. Again, I'm seeing, I know Ethics Commission deals with the intricacies of election law and, you know, who's a political candidate and who isn't, and how money can be spent. But you're forgetting again, I'll bring it up again, Prop 59, Constitutional Amendment. A provision that your fine attorney here can't even speak to tonight about. He told you I can't speak to that off the top of my head. The provision says, well, there's ambiguity, you know, you have to interpret any law or court rule or other authority broadly, not narrowly. So I'm not seeing you do that. I'm seeing you adopt these things narrowly. Additionally, you have to adopt findings to justify any new rule that you do. You haven't adopted any findings for any of this stuff yet. So that's in the California Constitution. So I don't know why you're progressing down these points without addressing those really critical aspects of Prop 59, which is the open government provision. Additionally, I would recommend that when you have a question about the interpretation of the Sunshine Ordinance, you defer to the body that is empowered to interpret the ordinance. And that body is the task force. If you have a question about managerial employees versus non-managerial employees, write it up and send it to task force. They are the experts. They are given the power. That's their jurisdiction to interpret the ordinance. And defer to them. Find out what their experience and the power that they are given by the voters to interpret the ordinance, and defer to them for that information. Especially when they actually know the California Public Records Act, they know the Prop 59, they know the relevant provisions of law that unfortunately your council doesn't, and your staff doesn't either. Additionally, I just point out to you in 6735D in the Sunshine Ordinance, it says, any person may institute proceedings for enforcement and penalties under this Act on any court or competent jurisdiction or before this commission. So clearly you have the power, and that's not limited to any willful or managerial. It's you have the power to enforce under the Act. And that covers all complaints that are referred to you by Sunshine.
Good evening, Commissioners. My name is Bruce Wolf. I'm the Vice Chair of the Sunshine Ordinance Task Force. Pleased to meet you. This is probably my first time meeting you all and meeting me. I hope that we can meet each other again to discuss some of these matters in more detail in the future. I think what's important is not to I'm going to suggest that you not take any action tonight. And the reason why is because there are some issues that our legal counsel might have that are different than what your legal counsel has. And I think that meeting needs to happen in a public session. I think that's just really important, especially with regards to the first decision that you were discussing, that I had just walked in after public comment was over, around the differences between the first sentence and the second sentence. And there are some pretty standard rules of constitutional law when there are statements made at the beginning of a sentence of a paragraph that carry through to the end of the paragraph when there's no break in a paragraph. So I think those things need to be laid out. It's been quite clear with our attorney that if everything's contained in a paragraph, that they hold true from what is said from the beginning of the paragraph. So I think it would behoove us all to make sure that we are all on the same page, or that we come to some agreement, or that if we are in disagreement, that we find some body like entity or some body of law to help us determine exactly how this is supposed to be read and what is the force of law. I think that would behoove us all, so this doesn't get prolonged ad infinitum, and would save us all a lot of time. So I appreciate your time, and again, I would reiterate what the last speaker said around 6735, because I was going to mention that that there are provisions for enforcement by your body to any person that chooses to bring it forward, even though there are some conditions. They have had to, it would have not had to have been taken up by a city or a state official otherwise, but be it as it may, there is that provision. So thank you very much for your time.
Good evening, Commissioners. I'm Richard Nee. For the benefit of your record keeping, it's Knee, just like elbow. First of all, again, I want to thank the Commission for its patience on this whole thing. This has taken a lot longer than you would have liked. It took a lot longer than we on the task force would have liked. But we're an all-volunteer body, as you are. At times we had trouble mustering or maintaining a quorum, and that prevented our moving forward with this as quickly as we would have liked, as quickly as you would have liked. So it's dragged out a lot longer than we all would have liked, but continued patience on this, I think, is of paramount importance. One other thing, as you move forward with this, I think one of the things that you're going to want to consider is the intent of all the sunshine laws. And in the case of the sunshine ordinance, there are 3 people I think you might want to bring in consultation on this. First one is Terry Frank, F-R-A-N-C-K-E. He is the General Counsel of Californians Aware. He wrote the original language of the first ordinance, the 1993 version of the ordinance. Second and third are the co-drafters of Prop G in 1999. Their names are Thomas Burke, B-U-R-K-E, and Stephen, with a P-H, LeBlanc, capital L-E, capital B-L-A-N-C, I believe that's one word. Both of them, all 3 of them, are still practicing. And if it is the will of the Commission, I will be happy to provide you with their contact information. And again, I encourage you to bring them in on this.
Thank you.
Good evening, Commissioners. My name is Dr. Allison Washburn. I'm Chair of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. I'm also past president of the League of Women Voters of San Francisco, and I hold Chair 5 on the Sunshine Ordinance Task Force, which is the League's chair. And I wanted to comment, first of all, Commissioner Studley mentioned a while ago about how complex these issues are. And in preparing for tonight's hearing, I reviewed a lot of material and then read Mr. St. Croix's analysis and his recommendations. And after having decided that I was, looking at all of this one way, some questions arose and continually arise. I think that it would behoove all of us to schedule a joint meeting where we sit down as peers with different areas of expertise to review these very complex issues that are interesting and very, very important, and bring in the various people that Richard Nee just recommended, who drafted all of this in the first place, have our respective DCA members with us. I think all of these good heads could hash out these complex issues and come up with some regulations that would be helpful to us respectively and certainly to the public. So again, I respectfully invite you to join us in discussing all of this further before you take action. Thank you very much.
Commissioner Ray Hartz, Director, San Francisco Open Government. These comments reference Decision Point 2. If the Ethics Commission decides to adopt this staff recommendation as is, it will result in all city boards and/or commissions being exempted from the Sunshine Ordinance if they so choose. Since neither board nor commission members nor their staff are typically, quote, elected officials, department heads, or managerial city employees, unquote, they could reply or not reply to such requests with impunity. They would know that the worst that could happen is the referral to the Sunshine Ordinance Task Force with no available avenue to the Ethics Commission for enforcement. Should it choose to live up to the moral and ethical obligations I believe it has, at a minimum, the Ethics Commission could place pressure on members of boards and commissions to comply with the law. In such cases where unable to exact a penalty, the Ethics Commission could use moral suasion to ensure compliance. And that was one of the issues was related to my complaint with the Library Commission. One of the reasons it was dismissed by the staff was because this person was not a managerial employee, etc. Well, that's basically saying they can just disregard the law because you're saying you can't do anything to them if they do. And that's pretty much the attitude they've taken with two determinations on the same issue. They have simply refused to comply. Now, I'd like to just take a moment to kind of give you a sense of what I feel I've been hearing from members of the public, which is you have the Sunshine Ordinance Task Force, which is composed of members who have for a dozen years been dealing with all of these complex issues, and you are attempting to do something that you have basically never done as a body. You have left all this work in the past to the staff, and it would be hard for me to understand how you would really understand any of these issues without reference to using all of the experience that is provided by the task force. You could sit down, hash them out, and you, the commissioners, are the ones who have to make the decisions, not the staff. And I've said this before, if you don't do that, my feeling is you've abrogated your responsibility, you've delegated to the staff, and then you say, oh, our staff is wonderful and they told us this, and you have to go with it. So we're matching 12 years of experience of the task force members in that body at dealing with all of these issues against your one case that you have heard, period.
Good evening, Commissioners. My name is Suzanne Manning. I hold seat 4 on the Sunshine Ordinance Task Force. I'll make my comment brief, essentially to echo my colleagues on the Sunshine Ordinance Task Force and just really highlight how extremely critical it is because of the fact that a lot of these issues are so complex and the unfortunate fact that we have not had the most ideal form of communication and cooperation. It will certainly behoove us as a Sunshine Task Force, as colleagues working with you as commissioners, and as well as the future for open government and the entire city of San Francisco in going forward to really meet and discuss these issues. I really hope that you consider this and everything my colleagues have said. Thank you.
John, you're going to look great on TV, man. You and I share the same heritage and complexions and stuff that dies in front of the big screen. I just have one thing to say, and I have it for Ms. Studley and Mr. Hurd. The thing that stood out in this entire meeting to me, pardon me, I'm a layman. I mean, I do nothing but read this kind of stuff. But the thing that stood out was when Alan Grossman stood up there and said, I just celebrated my 60th with my class 60 years ago from law school. I mean, my God, 60 years, that's unbelievable. And then Commissioner Hur insulted him because he said, experience means nothing. Now, so I immediately went up to the guy and I said, Counselor, 60 years. How many people showed up at the reunion? He said, 32 out of a class of 550. I said, that's fantastic. I said, what was the school? And he said, why, it was Harvard. And you know that, Commissioner Hurd, you know that Commissioner Studley, because you both went to Harvard. And please don't insult elders in the presence of other elders. There's nothing the matter with experience. Now you want to shoot at me after I said, oh, Mr. Hurd, that's what you did to Mr. Grossman.
Hear, hear.
Okay, having heard all this public comment, I am thinking and reconsidering my earlier proposal, and interested in what other commissioners have to say on this, to simply table the issue. I think we've spent time with the memo and with the ordinance, and I think we understand where the staff is coming from. But table it until further discussion, perhaps with the task force or with others, to ensure that we have as much public confidence as you can in the regulations that we ultimately adopt.
I'd be happy to make a motion to that.
As would I support that. I think that it's quite reasonable under the circumstances.
I think that's a good one.
Is there a motion?
So moved.
Second.
Public comment on the decision to table the discussion.
Commissioner Herr probably made the best decision of your career, whether that's 12 years or 60. I suggest that you all read the Sunshine Ordinance closely. Most of us closely, broadly, and not narrowly. Most of us who have filed complaints with the Sunshine Task Force chose not to come directly to this body because of your reputation on not exactly supporting open government from the citizen's perspective. Those of us who have repeatedly brought complaints to the task force and have repeatedly won referrals to this body have read every word, comma, and space in that ordinance. I think you need to not only hold this joint hearing with the task force, you need to schedule an all-day City Hall open to the public meeting all day long to go over every word of every one of your eventual recommendations. You cannot take away from the voters what they passed at the ballot box. So after you meet with campuses committee and the task force, what you really need to do is not write a regulation that attempts to overturn an ordinance. You need to turn it into amendments to an ordinance and take it back to the voters and let them decide. This is our city, our democracy. It's not up to a panel of 5 or Ms. Johnson's panel of 11. It's up to the voters. These are our laws, our democracy.
Commissioners Ray Hartz, Director San Francisco Open Government. And this is something that I in the past have said to the Sunshine Ordinance Task Force itself, which is it seemed in their discussions that they seemed to be spending much more time talking about why they couldn't do anything than talking about what they could do. And I really do feel that if you meet with the task force, they're a very agreeable group of people who want to really make this work for themselves and for you, and most of all, for the citizens of the city and county of San Francisco. They want to ensure that citizens have the right to speak, and it's amazing sometimes you go before certain bodies. I went before the police commission and was told, point blank, you're not allowed to talk about that. You're not allowed to question the way we handle our agenda. And this was a police commissioner who's an attorney, a member of the California Bar, and had gone through the Sunshine training 4 times. And he's standing there saying, you can't talk about that. I think one of the reasons you don't see as much discussion about the public comment portions of the Sunshine Ordinance is because many of us relax and we think, well, for good heaven's sakes, we have the First Amendment in the United States Constitution, we have the California Constitution, we have the California Public Records Act, and we have the Brown Act. I mean, how much more do people need to know that getting up in front of a body and speaking is a right that people have? And with rare exception, does any member of a body have the right to stop them? The same thing goes with public records. Public records belong to you and I and all the citizens of the city. They don't belong to the department heads or the departments or the employees or anybody else. They are public property. And the fact that many city employees do feel that it is within their right to withhold documents, which they have absolutely no right to withhold, and then drag the complainant through onerous hearings before Sunshine, only to find out later that it isn't going to be enforced anyway because you guys can't agree on how to do it. I've referred to the application for public records to the Sunshine Task Force as a long form to apply for public records. They are getting much better, and I think the experience they have would benefit you greatly.
I am still Richard Nee. Respectfully, I would suggest that any meeting you have with our Compliance and Amendments Committee be held after the first of the year for two reasons. Number one, it gives us a little bit of time a little bit more time, I think, to review the package that staff has put forward. And number two, holiday season's coming up, a lot of people are going to be traveling. It'll be, I think, easier to get people to a meeting if we wait till after the first of the year.
Next item, vote. Is there a vote on the motion pending? All in favor? Aye. All opposed? Motion passes. Next item on the agenda.
Mr. Chair, I know that you don't need a defense, and I think that the record as stated will reflect that at least I heard nothing in what you said to be disrespectful of Mr. Grossman, but simply to stand up for the quality and commitment of our legal staff. I think it would not be, I, for one, just don't want to leave the implication that you were disrespectful, because I have found that you are never.
I echo Commissioner Studley's comments and also echo Chair Herr's comments of appreciation to the staff for your very hard work and thorough analysis, which is very helpful for our discussion on sunshine regulations.
And I'm sorry that a number of people have left, but I would also like to thank the members of the task force, because I think some of the most constructive comments and the willingness to cooperate, I'm very influenced by Chair Johnson, Mr. Nee, and the Vice Chair who we just met, that they do seem to, and the other member of the task force who spoke to us, that I think there is a genuine invitation there to try and work through this, and I appreciate it.
I think that such a meeting is absolutely essential. We need to go through it. A meeting where there is nothing but that on the agenda.
I'd just like to chime in and say that I agree with all that's just been said.
The next item on the agenda is consideration of request for waivers for the post-employment ban regarding Ms. Tiffany Bohe.
Ms. Bohe is here.
Before we begin with this agenda item, I'd like to state for the record that while Mr. Bohe and I have never met, we don't know each other. My employer, your one Center for the Arts, is a SFRA project, and we receive a substantial portion of our annual budget from SFRA, and for that reason, I think it's wise that I recuse myself from consideration of this matter. And so I do.
Actually, you have to have a vote.
Is there a motion to for Commissioner Ward to recuse himself from this matter for the reasons stated?
So moved.
Is there a second?
Second.
Public comment? Seeing none, is all in favor?
Aye.
Aye.
All opposed? Motion passes. So
You have to leave the dais. You can stay in the room or you can go outside.
Mr. St. Clair, would you like to introduce this?
Yeah. The CIFRA is, although a state agency, is not another side. It's not a competing interest with the state. Its work dovetails with city work. So in this situation, our evaluation is that there's not a built-in conflict of interest. Ms. Bogie will be promoting the same objectives that she did in her prior job in her new job, and then they dovetail together. Invite her to come up and just introduce herself and give the commission a brief background on her request.
Through the chair, Tiffany Bogie. I'm the executive director of the San Francisco Redevelopment Agency. Thank you for having me here this evening. I'm here before you to request a waiver on 2 items, as your executive director has indicated. In my previous capacity with the city, as a project director for the Office of Economic and Workforce Development, my key role was to advance redevelopment projects which promote the economic vitality of the city, revitalize our neighborhoods, and provide housing for our poorest of the poor to those with working families. Similarly, the redevelopment agency, as Director St. Croix has indicated, the missions are quite closely aligned. There's no opportunity for me to have any undue influence or advantage. Both the redevelopment agency at the behest of the mayor and the board, and working closely with the city family, advances these goals to increase the tax base for our city, provide affordable housing. So I'd like to continue that role as executive director and be able to closely coordinate with my former employer and work cooperatively to advance these citywide goals.
Thank you.
Thank you.
Any questions for Ms. Bogie?
Can I ask a question?
Yes.
Ms. Bowie, thank you for coming tonight. In your letter, I think you refer to a legislative package that you're working on. Is that the only project for which you're seeking a waiver, or is there more to sort of your job in general that you need a waiver for?
I believe it's that specific legislative package. Should the last summer, the legislature and the governor pass some redevelopment realignment legislation to redirect funds to schools and certain taxing entities, but not all, like BART and other things. The California Redevelopment Association and the League and a couple of other cities, like Union City and San Jose, challenged that, the legality, the constitutionality under Prop 1A and Prop 22. The court is deliberating now. They just heard oral arguments. And should there be an opportunity for redevelopment to continue, and both the mayor and the board have indicated so in resolutions passed this summer, that yes, redevelopment for our city is a good thing, the promotion of affordable housing, neighborhood revitalization. That particular package of legislation, pending the outcome of the court decision, which we expect in January, is what I'd specifically be working on, what I've asked for that component of the quote-unquote switching sides, I think, waiver.
Okay, thank you.
Any other questions for Ms. Bogie? Thank you. Commissioners, any objection to taking public comment if there is any, before we discuss? No. Is there any public comment on this matter? Comments from the commissioners?
I think it's important that we look carefully at waiver requests because there were good and sound reasons that the restrictions were adopted, but I also think that we were given the ability to allow for waivers when it was did not pose a danger of the restrictions in the first place. And I think the staff's recommended, I don't know if it's a clarification or now a specification that it only be a waiver with respect to responsibilities at CIFRA makes sense.
Any other comments?
I agree. I think that we should take waivers seriously, but I'm persuaded that the interests are aligned and there would be no undue advantage or undue influence. And so given that and given the director, Jennifer Matz's recommendation as well, I would be persuaded to grant the waiver.
Is there a motion?
So moved.
All in favor?
Aye.
All opposed? Motion passes. Thank you for coming, Ms. Goki. The next item on the agenda is a closed session. Is there a motion to move into closed session?
So moved.
Is there a second?
Second.
Public comment, whether we should go into closed session? Seeing none, all in favor of moving into closed session?
Aye.
All opposed? Motion passes. We will move into closed session. So we need to clear the courtroom and do it.
Hearing.
What's that?
Hearing.
Oh, hearing room, sorry. Oh, wow. Yeah, definitely not.